Hello, IP friends. Welcome to hashtag IP series with your favorite podcast host, Rita Anweri Chinda, RAC. Now, if this is your first time listening to my podcast, you're welcome. I hope you find my podcast interesting. I hope you learned something. And also, don't forget to subscribe and favorite my podcast so you don't miss out on any other juicy episode. This year is going to be explosive, trust me, guys. And for my returning listener, I just want to tell you guys I love you, I appreciate you, and don't forget to also share your favorite episodes with your friends and your contact. It will mean a lot to me. So what do we do here? We talk about recent trends, cases, and development on copyright, trademark, patent, industrial design, trade secret, geographical indication, and plant variety. And with that, I welcome you to this episode where I will be talking to the creatives. So, like I earlier stated, today's episode is strictly for creatives. So, the creatives could be authors, songwriters, compositors, artists, anyone within the entertainment industry. Because this particular case is a very, very, very interesting one, and it features our favorite artist, and I love this artist. So this is a case. So the citation is Elliott against Cartagena et al. So this was a case filed in 2019 between a songwriter called Elliott. He sued Fat Joe and Remy in their hit song in 2016, Nothing Can Stop Me. I'm all the way up. I hope I don't get sued anyways, but yeah, he sued them for his own contribution in All the Way Up. And I'm going to tell you guys the whole gist. So the story goes like this. In 2019, Eric, who's also known as Fly Havana, filed a suit against Fat Joe and Remy Ma. Now, Fat Joe's real name is Joseph Cartagena, and Remy Ma is known as Reminis Maki. And he sued them, stating that they had cheated him out of his own share for compensation and ownership in the song he had co-authored with them, titled All the Way Up. Now, turns out that he was actually paid $5,000 for his contribution, and he was told orally that he would be compensated in future for any other earnings that came on, and that money was paid in 2016. So look at the time difference. 2016 was when the song was a hit and it came out and he was paid, and then in 2019 he's going to court to sue. Now, the interesting thing about this case is that he signed a contract, but he did not read the terms to understand what he was signing. Now, one of the clauses had stated that he was going to waive his copyrights in that song as a co-author in perpetuity, that's forever and ever, all over the world, and that he was not even entitled to any royalty payment. Now that's cold, guys. Like, you see some of this. So for every time I review a contract and I see in perpetuity throughout the universe, I always want to renegotiate, because one, it's very important that you negotiate how far your control over your exclusive rights would go. There has to be a timeline for how far that can also be exploited and commercialized at the end of the day. Failure to do that means you're foregoing both your moral rights and your economic rights. Now, if he says any other additional right, these are the rights we're talking about. Now, so I know this conversation came up last year when we had the Ameno Amapiano remix issues. Someone had responded to my post saying that some artists or creatives wait till a creative work like music um goes viral, or let me use the term that most people blows, where a song blows like it's a hit, to actually file, go to court and then try to get seek for redress or remedies or compensation. Now I get that aspect. However, as a contributor or as a joint owner or a co-owner of a creative work, should you not be entitled to compensation? Yes, you should. However, where you sign off your rights and you've been paid one off, so it's the same thing for producers. You're paid one off and then the song becomes a hit and then you come crying and saying, I made that song, I deserve to earn the royalties. What does your contract say? That's the first question I'm going to be asking you when you come to have that conversation with me. You just sign a contract, let me see your contract. What is the IP clause stating? What is the ownership clause stating? Those are the things I'll be looking out for. What is the percentage of your ownership? Is there a timeline? How are you making money from it? These are a few things I'll be looking at for. But then I had to point out, because I have a group called Entertainment and IP Hub for Lawyers. I had initially created it for River State practitioners, but I had to extend it, make it so we have like a network of entertainment lawyers and IP lawyers who want to learn. I'm still learning, and I believe that with each case everyone learns. Now, from this case I had, because of that conversation this morning, so the initial post was made on billboards, um and then Mark Jaffe, who has been a guest on our podcast, also shared his views from the United States perspective. So you guys should check out Mark Jaffe on Twitter to get his views about this case, while I will be talking from the point of a Nigerian point of view. So, one, things I feel songwriters should take note of. So, like I was saying, what can songwriters actually learn from this story? First of all, as a creative, have a lawyer, an entertainment lawyer or an intellectual property lawyer or your retainer, so they can read your contracts for you before you sign away both your economic or moral rights in your creative work, because your intellectual property can take you all the way up. Hey, did you see what I did there? um Secondly, in Nigeria, the owner or authorship in a copyrighted work is said to vest or belong basically to the first person who created the work. So in this case, Fat Joe, Remy Ma, and Eric are the first person. However, in the event of the event where, however, in the event where, so that's subsection 2 now, paragraph A and B says, in the event where it's commissioned by a person who is not the author's employer under a contract of service of apprenticeship, or not having been so commissioned is made in the course of the author's employment, the contract shall belong in the first instance to the author unless otherwise stipulated in writing on that contract. So the contract is what could make or break your ownership of a copyrighted work. It could make or break how you earn money from that copyrighted work. It could also make or break your exclusive rights that you are supposed to have. Now again, section 12 talks about right to claim authorship. To claim authorship in a work, it must be indicated with any other act referred to section 6 as in relation to the exclusive right to publish and the rest of them, right to perform in public. Then you can also object to seek relief in connection with any distortion, mutilation, or any other modification or any other derogatory action in relation to that work, where it will be prejudicial to your honor or reputation. So how do you claim right to your authorship? So you can read section 12 sub 1, 2, and 3. So the rights referred to here are perpetual, inalienable, and imprescriptible. Yeah. Then another interesting point again to take note of is stated in section 11 sub 6, which says that for the purpose of this section, persons shall be deemed to be co-owners if they share a joint interest in the whole or any part of a copyright, or if they have interest in the various copyrights in a composite production, that is to say a production consisting of two or more works. So does Eric qualify to be called a co-owner or a co-author? Yes, based on this definition. Now another subsection in section 11, I want to make emphasis on this, on section 11 sub 2, which provides that an assignment or a testamentary disposition of copyright may be limited to some acts in which the owner of the copyright has exclusive right to control, or to a party only of the period of the copyright. Now, the copyright in the musical works lasts for 70 years. Lasts for 70 years after the end of the year in which the author dies. So what that means basically is, for so let's say you live for about 60 to 70 years, your term of duration will still continue reading 70 years after you have died. So that means, in line with section 12 sub 3, author could include your heirs or your successors in title. So your heirs or anyone who is inheriting your property, your successor, can keep enjoying the copyright that comes with that work 70 years after you have died. So we've seen artists like the Marvin Gaye estate and Whitney Houston, Michael Jackson, Fela Kuti in Nigeria, Da Green as well. So yeah. Now this exclusive right, the exclusive rights in a musical work. So the exclusive right in a musical work that you as a copyright owner can exploit is the right to reproduce any work in any material form, right to publish the work, right to perform the work in public, right to produce, reproduce, perform, or publish any translation of the work, make any cinematograph, film, or record in respect of the work, distribute it to the public for commercial purposes, copies of the work by way of rental, lease, hire, loan, or any other similar arrangement. You can also broadcast or communicate the work to the public by a loudspeaker or any other similar device. And you can also make an adaptation of that work. And these are the exclusive rights accorded to a literary or artistic work. So you only, as the owner, these are the rights that you are entitled to explore. You can also license or assign this right to someone else. So for instance, artists can assign the right to publish their work or reproduce their work in any material form to CMOs. They can also assign it to their record label, the publishing company. So any of these right can be exploited in any form. So those are the ways creatives or artists, songwriters or co-owners, joint owners can actually commercialize and exploit their work. So you have the economic right to make money from your work. You also have the moral right to state how that work should be used. So it should not be used other than what it has been created for. So they can't use your work, say, for porn or anything that would not be considered to be in line with what you want. Now, this moral right can also be assigned in perpetuity, meaning that you don't even have a say what your work could be used to do. So it's best that before you sign a contract, you have a conversation with a lawyer, your own lawyer. So which I believe Eric should have done. So he's stating that he was pressured into signing that agreement. I mean, someone gives you a contract, why don't you just say, okay, I'm gonna get back to you. um so when someone decides to license or use any copyrighted aspect of your work, you're paid a stipend called royalties. Royalties is how you make your money. So you say, okay, for a term of 2 years or 3 years, you pay me XYZ, or whatever arrangement or method is used is dependent on the parties. But for this case now, I'm just going to keep mentioning what songwriters can learn. um I don't think this is like an infringement case to me. It's more like um the author wanting to earn from his creativity, and also wanting to be acknowledged as the author. But now the thing is, you were paid a one-off fee and then you signed or you waived your right in perpetuity, so that's going to be difficult. Again, like I said, if you want to know about the American or the US perspective, check out Mark Jaffe. Jaffe is spelled Jaffe, post on Twitter. Also, if you reside in Rivers State or any of the Niger Delta communities or states, and you would like to learn more about copyrights and how it affects the entertainment industry, the importance, its role, just send me a DM or send me a voice note here, or send me an email to ipseriesInfo@gmail.com. I intend to have a class sometime next month. I haven't decided the date yet, but I'm going to keep you guys updated. And as an author, you're entitled to economic and moral rights. A contract is what determines it at the end of the day. Now, in the event of a dispute, just like Eric went to the New York Federal Court, in Nigeria, you file your intellectual property dispute at the Federal High Court. If you don't want to opt for litigation, you can opt for alternative dispute resolution mechanisms such as negotiation, mediation, or arbitration. Arbitration are mostly for commercial disputes, disputes that are, how am I going to say this? Okay, let's just say commercial dispute. But then I don't know if there's an opportunity for Eric to sort of renegotiate what he had signed, as if he has a clause for that. I don't think so. But then I do feel for him that all he got for his contribution in All the Way Up, that was and is still a hit, is $5,000. I mean, come on, you should have done better. And I think maybe he was just I don't know. I really don't want to say more than I know. But then I hope creatives, songwriters have learned something. The importance of copyrights and contracts can stop you from going all the way up as a creative. So yeah. So guys, in conclusion, if you're in the creative space, in the entertainment space, in the literary space, artistic space, broadcasting space, copyright law applies to you. Your contracts are very important. Don't take it for granted. Make sure you vet it, make sure you read it, make sure you have your lawyer explain each clauses to you. Don't sign anything without negotiating the terms provided. And we're hoping that this new year we'll see more creatives, doing better in terms of signing proper agreements, and staying away from controversial disputes. Yeah. So now the New York Federal Court held on Wednesday that Wednesday being 5th of January anyways, that they had already paid Eric for his contribution to the song All the Way Up. So Another interesting thing is that while this case was going on, it turns out that the actual contract that the parties had signed was missing in action. So what did the court do? The court relied on the unsigned documents. That's the initial draft that was proposed to him before he signed. And I mean, it just shows you, it just goes to show you how complicated it is, because the judge in this case said there's no dispute that Elliott signed the contract, assigning his right to the song while simultaneously receiving the $5,000 check from Fat Joe in exchange. So you guys have learned something. If you did this, give me a thumbs up, retweet, like, share, favorite, and subscribe to my podcast. See you in the next episode. Cheers, guys.